Hello, everyone. This is Annie Cartwright, one of the attorneys in Husch Blackwell's Higher Education Group. We're excited to offer today a Year in Review Labor and Employment Case Law and Regulatory Development webinar for higher education institutions. Before we start, I'll cover a few housekeeping items. At the bottom of your audience console are multiple application icons that you can use during our presentation today. I'll highlight a few of them for you. If you have any questions during the webcast, please submit your questions through the question box. We'll do our best to answer questions during the webcast today, but if we need more time to answer or we don't have time to get to your question, we'll do our best to answer later by email. We really appreciate audience participation, so please, we encourage you to submit your questions via the question box today. If you have any technical difficulty, please click the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin credit, an HR Certification Institute and Society for Human Resources Management recertification credit as well. Indiana CLE credit is pending. To report your hours in Illinois, Indiana, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast is available tomorrow for watching and sharing, and once it's available, a link to the recording will be emailed to you along with your certificate of attendance. Joining me today doing the presentation is Scott Schneider. Scott joined our higher education group this year and works out of our Austin office. He assists education entities with complex legal issues, particularly sensitive institutional issues like response to sexual assault. He's a prominent litigator and a sought-after advisor on Title IX training programs, faculty hiring, promotion and tenure, and risk management within student affairs. So with that, we are very lucky to have Scott with us today. Scott, I'll hand it over to you.
Thank you so much, Annie. It's good to be here today, this morning, this afternoon, wherever you are. This is the first time I've done one of these with Husch Blackwell, and I like the use of the word widgets. There are a lot of widgets here, and if I screw them up, I apologize in advance. First off, I will just say today's inspiration, right from the very beginning, I think is going to be David Letterman, only because I'm envious of the beard at this point. And I'll just start off with, for those of you all who have seen me lately, I'm kind of right in between. I'm halfway to a full David Letterman beard, and so if you all have some objections to this, me going all out full David Letterman at this point, please send me an email at the end of this webinar and let me know your thoughts, or if you have any objections to me continuing down this path. We will start with some Supreme Court developments in labor and employment law. And we'll start with a case that goes back to June of 2018. It's the Janus versus the state, country, or county and municipal employees case, which came out in June of 2018. And here on our right, we have a picture of Mr. Mark Janus, who was a child support specialist for the Illinois Department of Health Care and Family Services. Mr. Janus was not a union member, and he objected that on a monthly basis he had $45 that was deducted from his monthly paycheck. And what he argued was that the taking of this $45 per month, which was taken out of his paycheck, to go to basically pay his fair share of union dues, that this mandatory deduction violated his First Amendment rights because it was compelling him, in essence, to finance speech by the union, which was in turn intended to influence the government on political issues. This case wound its way up through the various federal courts, all of which relied on a 1977 decision by the Supreme Court in Abood versus Detroit Board of Education to say, in essence, that Mr. Janis's lawsuit should be dismissed. Long story short, this case makes it all the way up to the United States Supreme Court. And in a decision that was written and rendered by Sam Alito, the court held that the $45 per month compelled fee violated Mr. Janis's First Amendment rights, specifically that requiring someone to pay for speech by someone else raises First Amendment concerns in whether, regardless of what standard used, strict scrutiny or a reasonable basis standard, that the compulsion here to provide union dues was a violation of Mr. Janis's First Amendment rights. And long story, to go back to the 1977 decision, it overruled the court's previous decision in 1977 in Abood versus Detroit Board of Education. And there's a lot that can be said about this case, but because of obviously the time constraints here, I can only do sort of a brief overview of these cases. But this decision, I think it is fair to say, has been or was a long time coming when you look at various opinions Justice Alito has issued around these issues. One of the interesting developments with this case, and this is something for my lawyer friends, this might end up being a good development for us, is that the court hinted that compelled bar dues may also violate the First Amendment. And what we are seeing, I think, nationally now are a whole host of lawsuits where attorneys are suing to challenge the compelled bar dues and to try to get their money back. It should be pointed out that it was my understanding, I think, that 22 states allowed compel union dues, and so 28 states didn't. You know, folks have talked about and speculated what the impact of this decision will be on public sector unions, and again, that's where it applies. And certainly in those 22 states where dues could be required, we are seeing a whole assortment of litigation asking for the unions to reimburse non-members for their dues. So that, I think, is probably from the Supreme Court world anyway, in terms of the labor world, this is probably the most significant decision to come out from the court over the past year. And we will see, I guess, what the consequences of this decision will be on a go-forward basis. We go from labor law to the band, Salt and Pepper. The year was 1992. I was still an undergrad. I had a much more substantial hairline than I have right now. And the song, Let's Talk About Sex, was nominated for Best Rap Performance by a Duo Group. Did they win? No, they did not. Who did win? It was DJ Jazzy Jeff and the Fresh Prince with their rendition of Summertime, which is a fantastic song. And you go, why are you giving me this minutia and trivia about 1992 rap music? Because we are going to now talk about sex. And what we're going to talk about specifically is, what does the word sex mean for purposes of Title VII and Title IX? If this makes you disappointed, if you were hoping for something else, I am very, very sorry. This will be boring legal stuff about what does sex mean for purposes of Title VII and Title IX. And here we have a couple of very interesting developments. We have, in February, the Second Circuit, in an en banc decision, looking at the case of Donald Zarda versus Altitude Express Incorporated. The picture on your right is a picture of Donald Zarda doing his job. He was a skydiver. And Donald Zarda, if you've ever been skydiving, would hook himself up to someone who had paid a lot of money for this experience. And before they jump out of the plane, the customer had expressed some concerns and reservations. And Donald Zarda said to her, you don't have anything to worry about. For me, I am a homosexual. I am gay. Long story short, she then complained to the company about what Donald Zarda had said, and the company fired Donald Zarda. And according to Zarda, what he claimed was this is a violation of Title VII, which prohibits discrimination on the basis of sex. And in essence, I'm being fired for my sexual orientation, and that should be a violation of Title VII. Now we have a tragic situation which happens while this litigation is winding its way through the courts. In one jump, Donald Zarda, his parachute doesn't open, he crashes, he dies. That is just a little bit of trivia here, and the lawsuit continues on with his family. And this is another case that winds its way up to the district court, to the Second Circuit Court of Appeals, both of which come back and they say that Title VII doesn't prohibit discrimination on the basis of sexual orientation. And they say that because there is tons of precedent that goes back 20, 30 years which says exactly that same thing. The Second Circuit Court of Appeals decided to hear this case en banc, which, if you know anything about the Second Circuit Court of Appeals, it does very, very rarely. But in a 10-3 vote, the Second Circuit Court of Appeals, which is one of your more influential circuit court of appeals, comes back and says that sexual orientation discrimination is a form of discrimination on the basis of sex in violation of Title VII. This was an en banc consideration. There was a 10-3 vote in favor of this opinion. It is a fun, interesting read if you are a higher ed, labor and employment nerd like me. There were 8 different opinions as far as I can tell. There was one, and it's the first time I've ever seen this in a federal court opinion. The word woke is used in the context in which higher education institutions are familiar with, which is a first. It's a very interesting case. And I would recommend, obviously, that you read it. Now, it should be pointed out that now we're starting to see the makings of a significant circuit split. The Seventh Circuit Court of Appeals, in a case, I think in late 2017, came back and said precisely what the Zarda Court said here. The 11th Circuit Court of Appeals, looking at the same issue, whether sexual orientation discrimination is a violation of Title VII, came back and said no. We also see, and I just saw this today and I tweeted about it, a split within the administration on this issue, with the EEOC taking the position that, yes, to discriminate on the basis of sexual orientation is a form of sex discrimination prohibited by Title VII, and the Department of Justice taking the opposite position. And they did that within the context of this litigation specifically. So that is the Zarda case. We fast forward to Stevens versus RG and GR Funeral Homes. On the right, we have Amy Stevens in this picture. Amy Stevens, biologically male, was transitioning from male to female. She was working at a very conservative funeral home. And the funeral home, I guess not surprisingly, had a dress code. Amy Stevens was ultimately fired for violating that dress code. She comes back and alleges that this termination violated her rights under Title VII and that this was a form of sex discrimination against her. And she alleges that, in essence, transgender status or discriminating against someone because they're transitioning or because of their gender identity is a form of discrimination on the basis of sex, which violates Title VII. And as far as I can tell, for one of the first times, a Circuit Court of Appeals came back and said, we agree with you. The Sixth Circuit, again, in an en banc decision, came back and said that discriminating against employees, either because of their failure to conform to sex stereotypes or their transgender and transitioning status, is illegal under Title VII. And in their decision, if you read it, again, a very interesting decision, they rely extensively on the Price-Waterhouse-Cooper decision from the Supreme Court, which discusses sex stereotyping and how that violates Title VII. We see this issue playing itself out recently in a New York Times article where the Trump administration Department of Justice is taking a very, taking a position on this issue that is certainly at odds, at least the Department of Justice's position is at odds with the EEOC's position with respect to, does gender identity or transgender status, is this a form, or to discriminate against someone because of their transgender status, is that a form of discrimination which implicates Title VII's prohibition on sex discrimination? The administration, at least through the Department of Justice, is saying no. They have also, both the Zarda case and the Stevens case, both cases are being considered by the Supreme Court for review. In both cases, the Department of Justice has filed briefs laying out at least the Department of Justice's position on these cases, which I'll summarize, I think, with 4 points here. The Department of Justice is in essence saying that up until 2017, Circuit Court precedent was clear that discrimination on the basis of sexual orientation or transgender status did not constitute the form of sex discrimination which was prohibited by Title VII. They then have a very specific definition of what they say sex means for purposes of Title VII. Sex means biological sex. It refers to the physiological distinction between male and female. They then, with respect to the Stevens case, say that there are various statutes, including VAWA, which explicitly discuss discrimination on the basis of gender identity. And they say Title VII doesn't include a specific inclusion of gender identity. It remains with the word sex, and that the failure to include gender identity in Title VII means that that form of discrimination, discriminating against people on the basis of transitioning from male to female, is not a form of sex discrimination which is prohibited by Title VII. Framing, I guess, the last part of this, what the administration seems to be suggesting in their briefing is that some form of sex stereotyping is lawful so long as that sex stereotyping applies equally to men and women. It remains to be seen whether or not the Supreme Court will ultimately grant writs or certiorari on these cases. In the past, the Supreme Court has previously, I think it was 2 years ago in the Gloucester County case, indicated that they might be willing to weigh in on this issue. I wouldn't be surprised that they decide to weigh in on this issue in this term. And again, the issue is going to be what does sex mean, primarily for purposes of Title VII, but presumably also whatever they decide with respect to the definition of Title VII, with respect to the definition of sex for Title VII, would apply as well to an interpretation of Title IX. And specifically, does sex discrimination as prohibited in Title VII include discrimination on the basis of sexual orientation and or transgender status? Sticking with the theme of sex, we have the Me Too movement, which I'm assuming at this point everyone is familiar with. What we are seeing, and what I'll talk about for about 5 or 10 minutes, is some of the fallout that we're seeing, I guess, both in my personal practice and nationally in some of the case law. First, there has been a discussion nationally and in different state legislatures about the possibility of banning mandatory arbitration provisions in sex harassment cases. This has been discussed. There was a piece of legislation a national piece of legislation, the Ending Forced Arbitration of Sexual Harassment Act, which I think has gone pretty much nowhere at this point. And there have been various calls in different states to discuss whether or not within a given state there can be a banning of mandatory arbitration provisions in the context of sex harassment cases. Obviously, if you have mandatory arbitration provisions at your workplace, this is something to continue to monitor. But that was kind of on the legislative side, one of, I think, the more significant post-Me Too developments. On the practical side, one of the big practical impacts of the Me Too movement, and this is a design feature, is what advocates are trying to do is make folks who are victims of sex harassment, sex discrimination, much more comfortable in feeling free to come forward with their complaints of harassment and discrimination. This is a Harris poll that I have here, and there are other polls. There's tons of data points on this, but generally speaking, the consensus is that post-Me Too movement, most employees, both male and female, are much more comfortable coming forward with allegations of sex harassment, sex discrimination, and even sex assault. That the barriers to coming forward that have existed perhaps for decades now are slowly but surely coming down. This has raised some interesting legal issues. For the first time in quite a while, we are seeing at the higher education level a whole host of legacy abuse allegations, complainants in legacy abuse cases coming forward with complaints of assault. A high-profile example of this is at the University of Southern California, where we have a gynecologist, Dr. George Tyndall. He worked at USC's Student Health Center for 27 years. There had been complaints going back to the 1990s that Dr. Tyndall had done inappropriate things with patients at the Student Health Center. Hundreds, I can't remember exactly the number. I think at this point there are over 400 lawsuits against USC stemming from allegations that Dr. Tyndall had sexually abused people at the Student Health Center. And asked why they're coming forward now, most of them are saying that after watching what has happened with the Me Too movement, that this is now where they didn't feel comfortable maybe coming forward in the 90s or the 2000s, they feel comfortable coming forward now. And I think it was last week at the University of Southern California, there was an announcement that they were going to pay $215 million to settle claims in a federal class action involving Dr. Tyndall. The breakdown, by the way, of that settlement is that $2,500 is going to any USC student who was treated by Dr. Tyndall. $250,000 goes to anybody who is alleging abuse by Dr. Tyndall. At least from the media reports that I've read, there are apparently 17,000 students who would be, if this settlement is approved, and it hasn't been, who could be potentially impacted by this settlement. Now, it bears noting, and you go, wow, $215 million, that is a lot of money, that there are plaintiffs' attorneys in the class litigation who are not happy with this $215 million and think more needs to go to victims of abuse, and they will be challenging the court's the court accepting this settlement agreement. There are also, as I mentioned, I think 300 other lawsuits that aren't even impacted, individual lawsuits that aren't even impacted by this settlement. So we see one of the colossal changes or implications or consequences of the Me Too movement is folks who may have been abused 10, 20, 30 years ago are now feeling comfortable coming forward with those allegations of abuse. And we see, at least in this case, both how complicated these issues are, how painful these issues are, and for higher education colleges and universities, how expensive resolving those complaints can be. Another high-profile example is over at Ohio State, where we have allegations, again, motivated by Me Too movement, motivated by seeing some of these other cases and folks coming forward. We have allegations from folks who were participants in the Ohio State athletics departments in the 70s, 80s, and 90s, coming forward with allegations that Dr. Richard Strauss, who his job was to provide everyone with a physical before they could participate in university athletics, coming forward with allegations that when he did that, he abused students and student athletes. Now, what's interesting about this case is Strauss has been dead literally since 2005. He committed suicide in 2005. Ohio State is in the midst of a lengthy investigation into the claims. I think hundreds, the last number I saw, 300 people have been interviewed. There's also tons of litigation that has come out of this. Again, we're talking about hundreds of lawsuits. So I suspect we're going to continue to see these issues on a go-forward basis as people feel more comfortable coming forward. I think there is perhaps a rough analog to what has happened over the previous decade with respect to K through 12 independent schools in terms of people coming forward with allegations from 20, 30 years ago of abuse. And we continue to see colleges and universities wrestle with the very weighty and difficult issues associated with this. Switching gears, Rizzo versus Iovino, again, an en banc decision of the Ninth Circuit Court of Appeals, an Equal Pay Act case. Long story short, Rizzo is hired as a math consultant by the Fresno County Office of Education, and she discovered 3 years after her hiring that she was being paid less than her male peers. When she objected to this, not making as much as her male peers, the county came back, her employer came back and said, well, the reason you're being paid less than your male peers is when we looked at salary history in hiring you, you weren't making as much as they were making in predecessor positions. So Rizzo decides to sue. And long story short, this is the case again, winds its way up through the courts in California. She loses at the district court. She loses at the Ninth Circuit Court of Appeals, and then the Ninth Circuit decided to hear the case on an en banc basis. The gist of the case is fairly straightforward. Under the Equal Pay Act, an employer can escape liability for a disparity in pay between men and women by arguing, in essence, that the disparity is based on a seniority system, a merit system, a system which measures earnings by quantity or quality of production, or, and this is the important one, this is this catch-all provision, a differential based on any other factor other than sex. What does the county argue? The county argues that salary history or previous salary history is another factor other than sex. Therefore, we get to take advantage of this affirmative defense, and therefore, Rizzo's lawsuit should be dismissed. In a decision authored by Judge Reinhart, Stephen Reinhart, and was issued, I think, 2 days after his death, the Ninth Circuit in an en banc decision comes back and says, no, that the use of prior salary history perpetuates discrimination, and therefore it is not a differential based on any other factor other than sex. We can't use prior salary history in the Ninth Circuit to justify disparities in pay on a go-forward basis. And in this regard, the Ninth Circuit now is aligned with the Second Circuit, the Sixth Circuit, the 10th Circuit, and the 11th Circuit, as well as, the last time I looked at the numbers, 18 states which prohibit the use of previous salary history in setting starting pay in a new position. There is an outlier at the 8th Circuit Court of Appeals, which has said this is a permissible practice. And so there has been some discussion that this one also has the potential to be considered by the Supreme Court in this upcoming term. The briefing has been done, and we will wait and see whether or not the court decides to hear the case. Fun little case out of the First Circuit Court of Appeals. This is Carlson versus University of New England. Here we have the thorny issue of what do we do when institutionally we make a decision that a supervisor has sexually harassed a subordinate employee, but the harassment wasn't bad enough to warrant immediate termination. So that, in essence, the person who has been harassed continues to have to report to the person who harassed him or her. In this case, what the University of New England decided to do was something a little bit creative. The faculty member who had complained that her department chair had sexually harassed her said she wanted to come up with a situation where she would no longer have to report to him, that she wanted, in essence, a surrogate supervisor. She goes to the provost and the dean with this request, and the university says, okay, we can facilitate this, but you will have to be removed from your department. And what the professor says is, well, that's fine with me so long as by moving from the department, this doesn't in any way change the courses I'm teaching, my teaching load, the sort of research I have to do. The dean says, fine, we agree to this, and seemingly have solved a very difficult issue in a subtle way, except they did not. When she was transferred to the new department, what happens? She's given courses in her field, but they are lower level courses. They are freshman courses, and she's used to teaching juniors and seniors. What does she decide to do? She decides to sue for retaliation. And here at the district court level, the district court comes back and says, you know what, we're going to grant the University of New England's motion for summary judgment because here the transfer was voluntary. You agreed to it. and therefore there has been no adverse employment action. The First Circuit, though, looks at this, comes back and says, we reverse. Why do they reverse? Because, in fact, the transfer, number one, was not what she agreed to, and in effect, the transfer was a material change in her working conditions, specifically that she was now teaching courses, lower-level courses that were not as interesting for her, and the court allowed the case to proceed, reverse the finding of summary judgment, and as I understand it, this case now continues to move forward. I don't have a ton of time to talk about this case out of the Third Circuit Court of Appeals, but it is a fun and interesting read, especially, I think, which illustrates some of the issues, especially in-house counsel wrestle with on a daily basis. So this is Courtiana versus Lafayette College, and it's a Third Circuit Court of Appeals case. And I'll give you the short scoop quickly. Students came forward complaining that a tenured professor at the university had made them feel uncomfortable. He then has all sorts of problems associated with this complaint. It causes him a lot of distress. He needs to go on leave. The university is using its tenure revocation process and policies, which can be time-consuming. He asks for various accommodations in that process, some of which are granted, some of which are not. He ends up suing the university for ADA violations connected with them not providing the disability accommodations. Fast forward, the university or the college wins that lawsuit. Ultimately, the college decides that the allegations against Courtiana are so serious, number one, the underlying allegations, and then second, allegations that he retaliated against these students, specifically that he singled them out in a presentation and made them uncomfortable, and that his lawyers had threatened the two students with lawsuits if they continued to pursue claims against him, that those allegations, those acts were acts of retaliation, which also warranted the revocation of tenure. Interesting case, ultimately goes up to the Third Circuit Court of Appeals, where the college is arguing that these are legitimate business reasons, and ultimately the Third Circuit Court of Appeals decides to affirm the dismissal of the claims against Lafayette College. Really interesting historical case, though, for a variety of reasons. And I think it shows some change in the way colleges are approaching these issues. First of all, that these complaints and the retaliation that took place after warranted tenure revocation, and number two, that the court basically said, yes, we agree with the college in this case. I would recommend that you read the decision. It is a fun read, very interesting read, and I wish I had more time to discuss it. One quick issue, again, this is a post-Me Too development that may be unique only to certain states, but we have this lawsuit at Columbia, involving Columbia University, where one professor sues the university and another professor for sex harassment and for retaliation. Case goes to a jury. Jury says university should win, but that the retaliation claim against the individual professor, who I believe was being represented at this time by Columbia University, that was a valid claim. And ultimately the jury awarded $1.25 million to the professor, based on Geert Burkhardt, who is the other professor, his alleged retaliation. And I think there are interesting issues about, and first of all, in Title VII cases, there will be no individual liability. So this is in part because in New York, apparently, there can be individual liability for discrimination and retaliation. So it may be limited, the significance of this sort of case may be limited to a state where that is permissible. But really interesting questions, I think, about would an institution indemnify under that set of circumstances? What are the conflicts inherent in joint representation of a university and a professor accused of harassment and issues like that? And again, I think this case does a pretty good job of illustrating potentially some of the perils in, at least from the beginning, saying we will indemnify you and we will also provide a defense. Fast forward, we have McAdams versus Marquette University. Again, state case, Wisconsin Supreme Court. For me, very interesting case. I'll set it up quickly. We have John McAdams. John McAdams is a faculty member tenured at Marquette University. He also has a blog. I think it's called the Warrior blog or something like that. A Warrior with an A, not with an O. And he is a very conservative blogger. And one day a student comes to him and says, hey, I have a recording of my interaction with a teaching assistant. It's a student teaching assistant. I tried in a philosophy class, the student tells McAdams, to talk about the problems with gay marriage, and I was told by the teaching assistant to stop. And my free speech rights within Marquette University, which is a private school, were stifled. So McAdams decides to publish this recording, publish a disparaging blog post about the teaching assistant. Her name is Cheryl Abate. And people in the times that we live start picking up on this blog post and start harassing the teaching assistant. They harass her, give her such a hard time that ultimately she quits, has to leave Marquette University. Along the way at Marquette University, the administration is going to McAdams and saying, can you please take this down? Can you stop this? You're creating a terrible environment for a fellow member of the university community. McAdams refuses to do this. Ultimately, the matter goes in front of a university grievance committee, and there is a recommendation from the university grievance committee. This, coupled with a lengthy history of this sort of behavior, warrants termination. And ultimately, Marquette says, well, we're not going to terminate, but we're going to put you on leave without pay until you decide to take this blog post down. McAdams fights them on this, says, nope, I'm not taking it down, ultimately sues the university. And he sues for what he says is a violation of his right to academic freedom. And you go, wow, Marquette is a private university. The right to academic freedom, when we think of it in a legal sense, is a right created by the Constitution. Marquette isn't covered by the Constitution. What could he possibly mean? And so what he argues here is in his academic appointment letter and in the faculty handbook, there are numerous references to his right as a professor to academic freedom. And so this isn't a constitutional case. This is, as the Supreme Court of Wisconsin notes, a breach of contract case. And long story short, ultimately, the Wisconsin Supreme Court comes back and they say, when we look at the contract, when we look at the case law defining what academic freedom means, we think that the university has breached its contract with Professor McAdams because it has suspended him without pay for engaging in activity which is protected by the guarantee of academic freedom. One other interesting little tidbit in this case, if you were to go back 100 years and look at higher education cases involving colleges and universities, in faculty decision-making, there was what developed, and you can go back 200 years, something called the academic abstention doctrine, which basically said, hey, universities, courts were very, very deferential to the decision-making of universities, especially when it came to who should be teaching at an institution and who should be able to attend that institution. And what we've seen over a period of 10, 20, 30 years is a slow chipping away of that deference to institutional decision-making. There is a lengthy discussion of that in this case, and long story short, the Wisconsin Supreme Court comes back and says, no, when it comes to interpreting a contract and deciding whether or not a contract has been breached, we're not going to defer to universities in this regard. Again, very interesting case. For private schools, maybe only limited to certainly Wisconsin, but it was interesting, again, that the academic freedom argument was grounded in promises made in the appointment letter and in the faculty handbook. I looked at that as a culture war case. I will give you one other culture war case, which is very close to home. Very interesting case involving Glass versus the University of Texas, which received a whole lot of attention by the Chronicle of Higher Education and other media entities because the University of Texas, in their arguments about this case, focused on institutional academic freedom. And the reality is, when we think of academic freedom, and you can look at the case law that goes back for quite a while, there is institutional academic freedom. There's also professorial academic freedom, and at times those freedoms butt heads. In Glass versus University of Texas, though, here in Texas, we have Senate Bill 11, which is the campus carry law. And presumably what schools are supposed to do is allow public institutions in particular, allow students to carry weapons in a concealed fashion into their classrooms. Professors of the University of Texas and other institutions around Texas don't like that. And what they argued, at least in this Fifth Circuit case, was that by allowing the students or requiring faculty to allow students to come in with concealed carry weapons violated the professor's First Amendment rights. And it was a very interesting and I think novel argument that, in essence, if I am a professor, that I will be so afraid to challenge the views of my students by offering provocative takes, because by doing that I'm running the risk of someone taking their concealed weapon out and shooting me. So that is a short version of the argument. They specifically, and I don't know that this was a smart strategic move, expressed particular concerns about religiously conservative students and openly libertarian students. I was thinking, boy, this is going to be an interesting culture war case. I can't wait to see how the Fifth Circuit resolves this one. And they really went down a boring path and basically said, no, the alleged harm here is too conjectural and not specific enough, and therefore we don't think the professor has standing to bring this claim, and dismissed the lawsuit on that basis. So not the most exciting resolution, but that is the way the Fifth Circuit resolved that case. There's another case close to home, and I just think this one is fairly interesting. Again, Fifth Circuit case from May of 2018, Rombo versus the University of Texas Pan American. Short version, the legislature decided to abolish the University of Texas Pan American and instead merged it with the University of Texas at Brownsville into something called the University of Texas Rio Grande Valley. When they abolished the University of Texas Pan American, What they said was, if you are a tenured professor here, we will consider you for a position at the newly created university, but you're not guaranteed any sort of position at that university. Rambo ultimately applied for a position at the University of Texas, Rio Grande Valley, was not given a position at the university, at the new university, and decided to sue the University of Texas. His argument was twofold. Number one, I was denied due process in that I really had a position at the University of Texas, Rio Grande, and it was taken away from me without notice and an opportunity to be heard. The circuit rejects that argument, saying, no, you never really had a position at the University of Texas, Rio Grande Valley. Second, he argues, okay, fine, you're firing me at the University of Texas Pan American. I was a tenured professor. That was a violation of my due process rights. And the Fifth Circuit says, no, the legislature made the decision to abolish the University of Texas Pan American, and that's all the due process you're entitled to. Interesting, fun case. There are some predecessor cases as well about this merger, but I thought it was pretty interesting. Fast forward, Sixth Circuit Court of Appeals case in the ADA setting, Hostetler versus the College of Worcester. So in this case, we have not a faculty member, but a staff member who takes 12 weeks of leave for a child. After she has the child, she starts experiencing severe postpartum depression. And what she asks for on a temporary basis is the ability to work reduced hours. So she asks for, despite the fact that she's working in a, quote, full-time position, she asks for a part-time schedule for 2 months. Ultimately, the college decides, yes, we are going to grant this request for an accommodation. 2 months go by. She returns to work full-time, but her symptoms come back, and she can't work full-time. And so she asked once again for something less than full-time work. All right, I think it was 20 or 30 hours per week. Because she couldn't return to work full-time, the college decided to terminate her. And I think if you'd asked me maybe a decade ago whether or not the college would win that claim, I would say I thought the case law on if it's a full-time job, you have to be able to work full-time hours was pretty clear, and I thought the college would win that sort of case. Here, though, Hostetler decides to sue, and ultimately the Sixth Circuit takes a look at it and says, no, you lose. And there's some really interesting pieces here. Her argument, in essence, is that, look, I was able to perform all the essential job functions, and it didn't take me a full-time, the full 40 hours. And on that score, she had some very good testimony from people who worked with her at the college, who said when she was part-time, she was doing a great job, things like that. So she had very good testimony. But there's this great discussion in this case, I think, a great summary of where we stand with respect to and how we evaluate ADA cases now. One of my favorite pieces, and this is one of, I litigate a lot, and if I were ever to get this in a court opinion, I would be so depressed and despondent. This first line from the court, Worcester devotes almost 17 pages of its brief arguing that Hostetler's mix of postpartum depression and separation anxiety is not a disability, forcing us to address that issue. Under the post-2008 ADA law, Hostetler plainly is an individual with a disability. So 17 pages gets dismissed in 2 sentences. And that's one of the things we've told clients for quite a while post-2008 is you almost assume at this point that someone is disabled. There are exceptions to that, but we start almost from the assumption that if someone comes to us with a health impairment, that they're probably going to be disabled for purposes of the ADA. Again, I think this is a really interesting decision. The crux of this case is whether Hostetler was otherwise qualified for her position. The analysis does not lend itself to categorical rules. It is highly fact-specific. Whereas, like I said, in the past, maybe a decade ago, we'd go, oh, you can't work full-time anymore. Now we're going to have to let you go. This case is suggesting what I think is the clear way courts are starting to resolve this is, no, we take each case on a case-by-case basis. Although this court has stated that regular in-person attendance is an essential function of most jobs, it is not unconditionally so. Courts must perform a fact-intensive analysis. And we can go on. There are other really good lines here. But generally speaking, what the court comes back and says is, these are the essential functions of the job. She could do them in 20 or 30 hours. Therefore, no, she is a qualified person with a disability, even though she can't work a quote-unquote full-time schedule. Similar case out of the 11th Circuit Court of Appeals, which is Sneed versus Florida A&M. Here, the issue was not about working a 40-hour week, but was working, whether it was an 8-hour shift or a 12-hour shift. This police officer could only work 8-hour shifts. The administration was saying, no, you need to be able to work 12-hour shifts. Long story short, the request for an accommodation is denied. The officer ends up retiring and sues. And the 11th Circuit Court of Appeals looks at the job description, for instance, to see are 12-hour shifts required in the job description, which, as we know, some deference is given to what we put in our job description. It's not there. Ultimately, the case goes in front of a jury, and ultimately, Florida A&M loses that case. Get out of ADA world. We'll spend just a couple of minutes as we're coming close to the end. I want to be respectful of everybody's time. We know the Harvard case is currently being tried. That is a student admissions case. There has been a considerable amount of activity under the surface in this administration regarding challenging the use, employment of affirmative action practices, primarily in admissions. We are starting to see, I can only tell you anecdotally, that we are starting to see some challenges to the quote-unquote diversity practices of institutions of higher education on the employment side as well. And I have been saying for quite a while now that I would not be surprised if, on the admission side, I feel like the case law is fairly well settled at this point. The Supreme Court has looked at this issue 4 times now. It is a lot less settled, in my opinion, on the employment side, and I do think over the next couple of years, and I'm already starting to see this anecdotally, that we will see some more challenges to institutional decision-making with respect to the use of race and gender in the hiring process as well. I will close with another race case, this one out of the Second Circuit Court of Appeals. This is a harassment, a race-based harassment case. There used to be, I used to have a string site about a decade ago for summary judgment cases which listed every terrible set of facts and where a court said, well, that's not sufficiently severe or pervasive. And what I can tell you, I think, is over the last 5 years, one of the things that's changed both in terms of sex harassment and certainly race harassment claims is courts are allowing cases that may have been dismissed 10 or 15 years ago on failing to establish severity or pervasiveness. They're allowing more cases to move forward now that 10, 15 years ago probably would have been dismissed. I don't know if 10 or 15 years ago this one would have been dismissed. Depends on the circuit, but here, at least in Robinson versus University of Illinois, it really what struck the court as significant was the use of a racial epithet. Even within, there was some context for the use of the racial epithet. But here the court basically said, no, multiple uses of the N-word, that's enough to be sufficiently severe or pervasive to alter an employee's working conditions given kind of the history of that word. And so I'm right at 1:02. I went 2 minutes over. Boy, we covered a lot of material, and I'm now exhausted. Annie, you want to come back?
I'm back. Thank you, Scott, for addressing all those interesting cases and the shifting tides in labor and employment law for colleges and universities, and addressing various facial hair concerns. Thank you to audience for joining us for our program today. We really hope that the information we provided was helpful to you and to your institution. If you haven't already, please do click the survey icon at the bottom of your screen to complete our short survey. The question that we are most interested in perhaps is, what topics would you like to hear about in the future? What keeps you up at night? What articles do you have by your bedside table that you've been meaning to read for years that we can help break down for you? As a reminder, this program has been approved for continuing legal education credit in Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin, and credit is pending in Indiana. It's also approved for HR certification, Institute and Society for Human Resource Management credit as well. A recording of the webcast will be available tomorrow. When it's available, a link will be emailed to you along with your certificate of attendance. The recording will be available for 2 weeks. Please be sure to join us for our next webinar on November 29th about the relationship of academic freedom and free speech on campus. This concludes our webinar.
Can I say one quick thing? Yeah, so I know there are a lot of questions. I promise if you email them to me at the email address I have right here, I promise I'll respond. I also see one question about Second Circuit. You're right, it was the Seventh Circuit. I made a mistake. I am mortified. But if you send me an email with your question, happy to give you a response, and won't bill or anything like that. All right, take care. Thanks.
Thank you all so much.